We continue to enforce the laws of this country. We continue to remove individuals who do not qualify for relief under the laws of this country. We are surging resources to the southwest border. We are improving the efficiency of our processing. We are elevating the enforcement consequences that we are bringing to bear to those individuals who do not qualify for relief.
Like so much else related to the border, the legal issues at play are hotly debated, and you can expect the rhetoric on both sides to ratchet up as the Supreme Court prepares to hear a crucial case which will shape immigration enforcement policy in the U.S. At issue is a memo drafted last September by Homeland Security Secretary Alejandro Mayorkas titled Guidelines for the Enforcement of Civil Immigration Law. The memo spells out a targeted policy for detailing what DHS calls undocumented non-citizens. Essentially, the document calls for the removal of criminals and threats to national security to be prioritized, while others are treated in a more hands-off fashion. Mayorkas wrote, quote, "It's estimated there are more than 11 million undocumented or otherwise removable non-citizens in the United States. We do not have the resources to apprehend and seek the removal of every one of these non-citizens. Therefore, we need to exercise our discretion and determine whom to prioritize for immigration enforcement action. In exercising our discretion, we're guided by the fact that the majority of undocumented non-citizens who could be subject to removal have been contributing members of our communities for years. They include individuals who work on the front lines in the battle against COVID, lead our congregations of faith, teach our children, do back-breaking farm work to help deliver food to our table, and contribute in many other meaningful ways." So you get the picture. Mayorkas is imposing a more lax immigration enforcement policy. And as is spelled out later, the memo that sort of look the other way policy applies to all but the migrants who are deemed to be serious threats. The memo prioritizes the threats to national security, defined as suspected terrorists and spies, threats to public safety, specifically those who've engaged in, quote, serious criminal conduct, and threats to border security, which is basically anyone caught in the act of crossing the border. Texas and Louisiana have objected, and they filed a lawsuit to reverse it. They argue that that DHS memo violated congressional directives spelled out in the Immigration and Nationality Act, specifically as they pertain to ICE detaining criminals, whether or not they engaged in serious conduct. The Biden administration argues it's got prosecutorial discretion on how to allocate its resources. Historically, courts have given a pretty wide berth to the executive branch to exercise prosecutorial discretion. But in June, a Trump-appointed federal judge in Texas sided with the states and ruled Mayorkas' guidance to be unlawful. In his ruling, Judge Drew Tipton found that, quote, "The legal issues are varied and complicated, but the core of the dispute is whether the executive branch may require its officials to act in a manner that conflicts with a statutory mandate imposed by Congress. It may not." Judge Tipton's ruling was upheld by the Fifth Circuit Court of Appeals and remains in effect as the Supreme Court gets ready to hear the case in early December. And if you're thinking maybe it's going to go one way or the other, it's important to note that in a similar case last June, the court sided with the Biden administration pulling the plug on the so-called Remain in Mexico program, a Trump-era policy which required migrants seeking asylum to stay in Mexico while their cases were being processed. The High Court ruled there that federal immigration law gave the Biden administration the authority to end the policy. And crucially, as it pertains to this new case, Chief Justice Roberts cited that the relevant statute in the case, quote, "plainly confers a discretionary authority to the president." And just as a note, I've often said it's important to highlight decisions like that at a time when so many believe on the left that the court only decides things in one way. Well, they don't always decide it in one way. But we'll get to that in a different day. Joining our conversation is Leon Fresco. He's the former Deputy Assistant Attorney General for the Office of Immigration under Obama. And back with us is Ron Vitello, former Acting Director of ICE under President Trump. Thank you both for coming back. All right, let me start with you on the legal side here. We saw the Biden administration get a Supreme Court victory on the Remain in Mexico case with Chief Justice Roberts, citing prosecutorial discretion as the basis for the decision. What do you make of that based on your experience working as an attorney focusing on these cases?
Well, the Remain in Mexico decision was different than this prosecutorial discretion, and I'll explain why. The Remain in Mexico statute says the president, or in this case, the Secretary of Homeland Security, may move a foreign national to a contiguous territory if they chose to, as a way to deal with that foreign national unlawfully crossing the border. And so the argument that Texas tried to make in that case was that the statute may meant one of two things. You either had to put the person in detention or you had to put them back in Mexico. Those were your only two options. And what the Roberts court held was that no, may means may, meaning unless you give those two choices explicitly, those are not your only two choices. May means may. And so may here means that the Biden administration could choose to have a Remain in Mexico program or could choose not to have a Remain in Mexico program. And so that's why they allowed the Biden administration to not have the Remain in Mexico program, because the statute said may. Here, the statute in the case that we're going to be talking about now with the prosecutorial discretion does say that when ICE encounters an individual who fits under certain criminal convictions, they shall detain that person. And so the question is, does the prosecutorial discretion memo, which is trying to say how to allocate resources, allow the administration to allocate those resources in a manner that when it encounters a person that the statute says it shall detain, can it now shall not detain that person, essentially? And so that's what the court is going to be deciding in this case.
Right. All right. Leon Fresco, thank you. Ron, I'm going to just ask you to stick around. Thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.